be, we're into week 6. Normally we meet on a Monday evening, but given that this is Christmas week 2019, I'm presenting the material in relation to discharge by performance or agreement in this 2-camera session. So when we talk about discharge, there are a number of ways that a contract may, as it were, come to an end. One is that it might be performed. In other words, the parties have fulfilled their commitments, the contract comes to an end as a result of that. Now, it may be that it comes to an end unconditionally or on conditions, and it may be that the parties may have an agreement about that. So generally, the termination, whether it's through performance or by agreement, will involve some finalisation of the commitment of the parties. So when we talk about performance of the contract, we're really talking about that which the parties had committed to undertake and complete as was expressed in the contract. Sometimes it's not entirely clear whether a party has fulfilled the commitment within a time period or not. So the time period may sometimes need to be performed within a reasonable time. In other words, the courts will imply a time stipulation determining when performance is due rather than by reference to when it's due rather than necessarily when it was created, that is the contract. So in the notes, you'll see that some of the terms that we'll use this week relate to conditions precedent, which are conditions that need to be fulfilled before the contractual obligations take effect. Conditions subsequent, which are conditions that terminate the contract effectively once those conditions occur. And we'll talk about part performance, substantial performance, and within that concept or those concepts, we'll also talk about severability. So when it comes to performance, it may be that one of the parties has performed, the other may say, no, you haven't, alleging that the first party's in fact breached the terms of the contract. So there's always going to be this fundamental issue around whether the obligations have been performed or whether the contract has been breached. If a party is alleging that the other party has failed to perform, before taking action, there is a thing that the party needs to consider, and that is whether they have themselves committed undertaken their commitment under the contract, or if not, whether they're ready to perform. In other words, if we look at the terminology of McDonald against Denny's Lascelles, which is 1933 48 CLR 457, the question is the plaintiff ready, willing, and able to perform? Now, that sometimes occurs in the context of a contract where time is of the essence, in which case, once we get to that stage, we reach that date, if a party can establish that they're ready, willing to, and able to perform at that time, then they're on safe grounds. But what if the party is ready, willing, and able to perform, and time is not of the essence, or it hasn't been specified? Then the party needs to be a little careful before taking too much action. For example, it may be that they need to put the other side on notice and give them notice requiring fulfilment of their conditions within a reasonable time. And to make that less vague, it may be that the first party, the one that is ready, willing, and able to perform, gives notice to the other party requiring performance within a reasonable time, which is stated as being 7 days or 14 days, whatever it might be. And the intention of that action is to put the first party, the party that's ready, willing, and able to perform, on safer ground before taking action. The idea of the notice is essentially to create time to specify or create a situation where now time is of the essence for the other party. Now, of course, there may be some cooperation in performance. In your notes, you'll see reference to the decision of Strati against JAG Investments from 1980. Essentially, in that case, the contract was subject to council approval to a plan of subdivision, and the court implied that the parties would take reasonable steps to procure fulfilment of that condition and refrain from taking steps that would prevent fulfilment. So courts will readily deem a couple of conditions into contracts if the conditions are otherwise silent. One is that performance is within a reasonable time, and the second is that the parties will reasonably cooperate in fulfilling that performance and certainly not do anything that will stop the other party from being able to fulfill performance within that period. So the doctrinal basis of that is estoppel. In other words, a party is estopped from relying upon unperformed terms as a defence to an action. There is a distinction between a doctrine of exact performance and other doctrines, substantial performance, for example, or part performance. When we talk about exact performance, it's really that doctrine that says if there is a commitment imposed on a party to undertake something to fulfill their requirements under that contract, then the exact performance must be read literally. In other words, if the contract is not fulfilled to the letter, as it were, then that party is not entitled to claim under the terms of that contract against the other. A very common example is entire contracts, which is where a party commits to fulfill an entire obligation. Failure to fulfill that entire obligation at common law, based on the doctrine of exact performance in the context of an entire contract, would mean that that party is not entitled to receive anything. And the leading case there, very old, 1795, is Cutter and Powell. And you would have read about that case. Cutter was a sailor, and if Cutter completed the journey, he'd be paid, but he died during the voyage. His estate brought an action for part of the earnings, and the court held that the obligation to pay Cutter did not materialise because Cutter did not complete the entire journey. And the court held that that was an entire contract. Very harsh. And there are a number of exceptions now to the harshness of that rule that have developed over time. But still, the fundamental question remains, are we dealing with an entire contract or are we dealing with something else? Even if it is an entire contract, it's now qualified by a number of exceptions, and one of them is this concept of substantial performance. So the fact that the contract provides for lump sum payment, even though that's a significant issue, it's not necessarily conclusive of the character of the contract, and a contract will not be entire unless the parties have agreed that the sum is payable only in the event of complete performance. So if you're arguing a case one way or the other, look out for that provision as to whether the entire contract has this further specification to say payment will only be made in the event of complete performance. We contrast entire contracts with which are those that are severable or divisible contracts. So an entire contract is not severable merely because it provides that payment of the contract price is made over time. So building contracts are not severable necessarily because it allows for recovery of progress payments. But most contracts that involve a range of services performed over time will be regarded as severable or divisible as opposed to entire. And a court may find that it's reasonable to pay even a breaching party for the work that they've done. The contract would be severed or divided into part performance. A leading case, Steele and Tardini, which is 1946-72 CLR 386. In that case, Italian internees worked on a farm. Steele saw the internees effectively as slave labour. They were required to split wood into lengths of different lengths, and not all the wood was cut exactly as required. So Steele said, "I'm not paying." The court said, no, in this instance, the contract was infinitely divisible. Therefore, there was a requirement to pay for a contract per tonne, not for every single payment for the entire job. So the internees were paid at least for the wood that was cut to the proper length. When you're dealing with this area of practice, just be aware of the involvement of apportionment legislation. For example, in Queensland, the Property Law Act, section 232, that provides that rents and dividends and other periodic payments in the nature of income shall be considered as accruing day to day and apportionable over time. Another thing that can influence whether entire contracts are enforceable or not is the de minimis rule. So under that rule, minute failures or insignificant defects in performance will be excused. Now, I guess the contrast to an entire contract is a contract that requires part performance. And under the doctrine of part performance, a party may accept something less than full performance, but if they do, they can't later claim that the contract had been breached, but acceptance on the part of the innocent party must be voluntary. So leading case, Sumter and Hedges, 1898. Sumter contracted to build some stables for Hedges. Sumter ran out of money, couldn't complete the job, abandoned the contract, leaving behind the building materials, and Hedges used those building materials to complete the job himself. Question is, did Hedges accept partial performance of the contract? And the court found that he had not so accepted, but Hedges had no real option. A half-built stable was of no use. He couldn't get Sumter to complete the work. Removing the stable and starting afresh was not feasible. Hedges had not voluntarily accepted part performance, and therefore Sumter was paid for his materials, but not for his labour. Contrast part performance with substantial performance. Now, assume a party's completed all the conditions of a contract, but fell short relating to a warranty. Courts are reluctant to allow a minor failure to be the basis for refusal to pay a contract sum, and they will allow substantial performance in appropriate circumstances. And sometimes the requirement of merely substantial performance may be implied by the nature of the party's obligations. Have a look at Hunig and Isaacs, 1952, to All England Reports 176. In that case, Hunig was an interior decorator, was contracted to furnish and decorate a flat. The price was £750 and Hunig had been paid £400 in part payment along the way. Isaac found fault with two items, a wardrobe and a bookcase, and the defects could have been fixed for about $50 or £50 rather. However, Isaacs seized upon the defects, claimed the contract had been breached, and therefore refused to pay the outstanding £350. But the court said, no, the contract has been substantially performed, and Isaacs was entitled to the £50 to rectify, but not to withhold the further £300. In Australia, a leading case, Luna Park, New South Wales against Tramways Advertising, 1938-61 CLR 286. In that case, an advertising contract required contractors to display advertisements for at least 8 hours per day. And the court interpreted that as requiring display for substantially 8 hours, not literally necessarily 8 hours. So what we take from that is that usually courts do accept the argument that even in commercial obligations, courts will allow a degree of flexibility. Another case, Arcos and Ronison and Son, against Ronison and Son, 1933, Appeal Court 470. There was an obligation to deliver staves, which are vertical wood posts or planks in a building or other structure. And these were to be 1/2 inch in thickness. And it was held that it was not discharged by delivering staves substantially 1/2 inch in thickness. So it will depend on the circumstances, it will depend to a degree on the importance of the departure. Has there been sufficient or substantial performance? Will depend on the facts in each case. Another thing you might consider when you're dealing with this topic is the issue of an unjust enrichment. And in some circumstances, where a court finds that a contract is an entire contract, the basis of substantial performance may be the prevention of unjust enrichment. An unjust enrichment is essentially, as the name implies, an argument that it would be unfair for the party to profit unjustly and be enriched by the work of one party by relying to some degree on a technicality. Another issue that you might consider is obstruction. So what if one party prevents the other from performing, for example, by refusing to accept delivery of goods or failing to take some step necessary for the contract to be performed? Again, old case, 1831, Planch and Colburn. Planch was the author of a journal series and started working on an article, went to expense. The publishers ceased publication of the journal, refused to accept the article, but the court found the author should be paid for his efforts on a quantum meruit, that is, for the work that actually has been done towards furtherance of the contract, even though technically the circumstances would otherwise deny that person being paid. There are issues around the time. And so what if obligations are performed after a deadline? What is the effect on the contract? One of the key questions is time of the essence of the contract. Another question, is a breach a mere technicality, or is it likely to have a substantial impact? And does the breach deny the innocent party the benefit under a contract? So when it comes to the issue of time and non-performance strictly in accordance with the terms, there's some of the questions that you need to ask yourself. So what are some of the key points from what we've discussed so far? Well, first, in an entire contract, the general rule is that the first party must complete all of their obligations before the other party has any obligation at all. Strictly, an entire contract is not severable and an entire contract is not divisible. But there are the exceptions. One of them, the de minimis rule, says the law does not concern itself with trifles. Don't come here with that argument. You know it's insignificant. We don't want to know about it. Sure, the contract was not technically fulfilled exactly in accordance with the terms, and even though it's an entire contract, we're still going to allow it. Planch and Colburn is authority for the proposition that a party cannot require performance if the other party obstructs the performance. And if a contract is construed as severable and some of the obligations are performed and others are not, the innocent party may seek a remedy for the obligations not performed. They're some of the key points so far. Now, before a party takes action, I've already mentioned the rule in McDonald and Denny's Lascelles about being ready, willing and able to perform. Strictly, particularly in real estate transactions, we couple that concept with the concept of tender of performance. What it means is this, that one party must tender performance, that is, at an appropriate time, at an appropriate place, or at the appropriate date, fulfill their commitment, or at least purport to fulfill their commitment. And in a real estate context, what happens in practical terms is this. If, for example, the seller is ready, willing and able to effect settlement on the day nominated in the contract for settlement to occur, and the other side is not, the seller, before taking action, should establish that they are ready, willing and able, and that they tendered performance. And the way in which you normally do that is you write to the other side and say, we note that 3 January is the date nominated for settlement. We nominate settlement to occur at 3 p.m. on that day at this location, and here are the checks we require. That the seller will then go to that location at the time and tender performance. And usually that requires them to call out the name of the other party and preferably have witnesses to the effect that that was done. So that's what we mean by the tender. Another issue might relate to payment. Now, when the contract requires payment in cash, generally speaking, it is not good tender to provide a personal cheque because it's not payment in cash. From a commercial perspective, cleared funds through a bank cheque would normally suffice in that regard, and of course be far more preferable than carrying around $500,000, as it would be the case, for example, in a real estate transaction. But even then, bank cheques need to be careful, can be created through fraud. So a bank cheque is not always strictly as good as cash. So sometimes you need to be careful about the source of the bank cheque in those circumstances. Another issue that you may come across is vicarious performance. So if the promise is to be fulfilled by one party and then that party asks someone else to fulfill on their behalf, there may be a question as to whether the contract allows or explicitly or impliedly prohibits vicarious performance. So I guess it comes down to the specific skills of the party that has contracted to fulfill the commitment. If the contract requires the skill of that person, then the general rule is that it's not a task that may be subcontracted to another party without consent of the first party. I guess it might raise some issues in your mind about when you're engaging someone to fulfill a legal work for you, or accountancy work or engineering work. Are you engaging the individual or are you engaging, say, the law firm? It may come down to what are the terms of the contract. And of course, law firms would typically have a client agreement that would allow for the vicarious performance of a particular task by someone other than the person that you were dealing with originally. Now, of course, there may be termination by agreement, and the termination may be built in the terms of the contract. So the contract might state that one or both parties have the right to terminate the contract, in which case it may be that the commitment that was imposed on the other is no longer to be fulfilled. A leading case in this area, Commonwealth against Amman Aviation, 1992, 174 CLR 64. The Commonwealth terminated the contract, but failed to do so in accordance with the methodology in the original contract, and the court held that the Commonwealth's purported termination was not valid. Another issue might be termination by a contingency. So a contract might stipulate that termination under two different types of contingent conditions, that is, conditions precedent or conditions subsequent. As we mentioned at the commencement of tonight's session, a condition precedent, it's a condition that must occur for the contractual obligations to take effect. If the condition precedent does not occur, the contract is terminated, as opposed to a condition subsequent, which is a condition specifying an event, the occurrence of which will terminate the contractual obligations if that condition occurs. So if the condition subsequent does occur, then the contract is terminated. Have a look at the example in your study guide. So a very simple contract, including both a condition precedent and a condition subsequent. Nicole agrees to teach Mitchell to drive a motor vehicle. Mitchell agrees to pay Nicole $200 plus $20 per lesson. The obligations under the contract only take effect if Mitchell obtains a learner's permit, and the contract may be terminated if the learner's permit is suspended or withdrawn. So in that case, it may be that condition 3 is a condition precedent. In other words, if Mitchell does not obtain his learner's permit, then the contract's terminated, the obligations do not take effect. But condition 4 is a condition subsequent. The obligations have commenced. Nicole has begun giving Mitchell driving lessons, but those commitments, those obligations cease if Mitchell loses his learner's permit. Real estate contracts are often made subject to finance. An example, Perry, P-E-R-R-I, against Coolangatta Investments, Proprietary Limited, 1982 149 CLR 537. If the buyer is unable to obtain finance, the contract does not proceed. Have a look at Geipel, G-E-I-P-E-L against Smith, 1872. In that case, a shipping company contracted to transport coal by sea. It was from England to Germany. After the contract was signed, but before the ship left, war broke out between France and Germany, and France imposed a naval blockade upon Germany, threatening to capture or sink any vessel attempting to take supplies to Germany. Now, the transport company did not depart for Germany. The declaration of the naval blockade was enough to be seen as a condition subsequent, with the effect of terminating the contract. The act of war and acts of God may also constitute frustration of the contract, but the condition subsequent in this case was a little different from a technical perspective to frustration. So a condition subsequent is different from a clause allowing the parties to terminate at will or for their own convenience. You'll see in the notes some discussions about different cases where courts have disagreed on whether clauses allowing termination at will or convenience should be subject to an implied duty to exercise powers in good faith. And again, some conflicting cases, which might be handy if you're arguing a particular matter because you've got cases that go both ways in that point. Termination by substitution. This is essentially novation, and a contract may be terminated by agreement through novation, which is termination by substitution. So a new contract is set up in place. One of the terms of the new contract will be termination of the old contract. So termination by substitution, it's termination by agreement coupled with the formation of a new contract. And what makes novation different is that each party's release of the other from the first contract may form the consideration for entry into the second contract. Just a word of warning, watch the stamp duty implications associated with novation, particularly with real estate transactions. Sometimes parties buy a property in their own name, for example, go to their accountant, the accountant says, you really should have bought this in a company's name. So the parties may seek to novate the agreement, effectively cancelling the first, creating a second. That's all very well, but the Office of State Revenue typically would say we're entitled to two sets of transfer duty because technically there's been a transaction in favour of one party, then a separate transaction in favour of another. We'll have the stamp duty, thank you very much, on both. Or we call it transfer duty now in Queensland. The other concepts that may be relevant, termination by accord or release. Termination by accord is an agreement to release the other party from outstanding obligations under the contract, and they can do that by agreement for whatever reason they wish. Termination by release is where one party has completed their obligations, the other party hasn't. And if the party that has completed their obligations chooses to release the other party from those obligations, the release will be effective. It can be done by simple contract, but usually that would be undertaken by a deed, which is in solemn form, which means we don't need to worry about issues of consideration. So usually, if there's a termination by release, it would in fact be a deed of release. Deed signifying it's under seal and it's a deed rather than a contract. And then the final concept, termination by satisfaction. The party owed money may be regarded as having satisfied the obligation by receiving less than amount which was strictly due under the contract. Well, that's a flying overview, if you like, of the contents for week 6. Sorry it's not interactive. Thank you very much for your patience in listening to me this evening. Enjoy your break over Christmas, and we'll see you for week 7. All the best then. Bye.